Stacy Waner from Justice for Trevor. You recognize.
Thank you, committee members, for allowing me to speak before you today. My name is Stacy Snyder Waner, and I am here today in support of House Bill 651. On January 6, 2019, my baby brother, 32-year-old Lance Corporal Trevor Mark Snyder, was involved in a minor motorcycle accident in which he suffered a broken leg. It was determined he required surgery to stabilize the fracture and to stop the fluids found to be leaking from the bone marrow, putting him at risk for an embolism. 2 days in a row, surgery was postponed and no reason was offered. He was not provided with a CPAP for his diagnosed and documented service-related sleep apnea resulting from his tours in the Iraqi desert during Operation Iraqi Freedom. Nor was he placed on a monitor, even though the hospital was administering the narcotics Dilaudid and oxycodone, the final dose administered simultaneously. At approximately 5 a.m. on January 8, 2019, my 32-year-old, otherwise healthy Marine Corps veteran brother was found, and my parents' only son, was found ice cold and unresponsive. He was declared dead 30 minutes later. Also, we're not related to that Snyder. As a result of Subsection 8 of Florida's discriminatory wrongful death statute, my family is unable to hold those responsible for the death of my brother accountable because he was over 25, unmarried, and had no minor children. It's been mentioned repeatedly that bad things happen to everyone and people can't sue someone because they're sad. Voting in favor of this bill does not open the door for people to sue because something sad happened to them. It allows for the families of all Floridians to hold physicians accountable for severe deviation from the standard of care resulting in death. It is my fervent hope when medical providers know they will be held accountable, they will provide better medical care. Many of the people speaking out in support of this bill today are sad, as well as angry, hurt, and confused as to how the state failed them and their loved one. But ultimately, we know it comes down to cost, getting and keeping medical providers here in Florida. It has been said repeatedly, passing this bill would cause malpractice rates to skyrocket, cause an influx of wrongful death actions, cause a mass exodus of medical providers, and prevent providers from practicing in our state. I would argue this is purely the sky is falling argument, and this can be backed up by facts. In 2008, the state of Florida passed a law requiring all physicians renewing their medical license to complete a Florida physician's workforce study to assess the state's physician workforce needs. One area of great importance is the physicians licensed in the state who are not actively practicing. The average number since 2008 of the physicians that are licensed but not actively practicing is 15,735. The number one reason provided by these physicians for not actively practicing, approximately 47.72% of them said it's because they planned to move here and they were getting their licenses in order. Only approximately 3.44% claimed it was due to liability exposure. And even lower, only 2% blame medical malpractice rates. Since 2008, on average, 1,963 licensed physicians say they plan to relocate out of Florida in the next 5 years. Of those, the number one reason provided from approximately 23.31% of respondents was due to the family. Coming behind compensation, looking for a change, and other is liability exposure, only 13.25%. And in last place again was the worry about medical malpractice insurance rates, with only approximately 3.38%. Medical malpractice insurance premiums is another issue the opposition to this bill mentioned frequently. They make claims stating repealing the free kill law will lead to an enormous increase in medical malpractice premiums, causing doctors to leave the state and preventing others from moving here. Unfortunately, changing the law in 1990 did not lead to a decrease in medical malpractice premiums. In fact, insurance premiums across the board continue to rise astronomically into the late 2000s. If you look at the economy during this time, we were in a recession. All types of insurance companies, homeowners, auto, death, and medical malpractice raised premiums to offset their withering portfolios. As the economy improved, the premiums decreased. All of this occurring after the 1990 bill that was supposed to prevent these issues was enacted. This is all verifiable data as well. Clearly, liability exposure and medical malpractice insurance premiums are not an issue with gaining or keeping providers, nor are increased medical malpractice premiums as a result of medical malpractice claims. As the appellate court wrote in their 2019 question to the state Supreme Court as to the constitutionality of this draconian law, quote, "We are mindful of McCall's observations that, quote, a crisis is not a permanent condition, and that conditions can change, which remove or negate the justification for a law, transforming what might have been reasonable into arbitrary and irrational legislation," end quote. I would argue the alleged crisis this law was based on is no longer an issue. We consistently have a higher percentage of doctors coming into our state than the population increase. Those doctors coming in and leaving have rated liability exposure and medical malpractice as very low on the list of concerns every year for the nearly 13 years of this survey. Contrary to what some would like you to believe, medical malpractice premiums are more affected by our economy as a whole rather than they would be by allowing all Floridians access to holding dangerous providers accountable for death caused by medical negligence. Thank you for taking the time to hear this bill today and allowing all of us to speak. We implore you to vote in favor of this bill and give all Floridians equal rights under our law. Thank you.
Thank you.